Good afternoon, Your Honor. Oh, we got Jonathan. Can you hear us, Your Honor?
Yes, I can hear you. Give me just
So
one. Give me just
see-
one. Go ahead, Patty.
I see Mr. Manning. Or do you want to start with?
No, I got Mr. Schmidt. He's here in the courtroom.
Okay.
Mr. Schmidt's here. Ms. Curry's here. Dr. Corman's available. So,
Okay.
Where's Mr. Krill?
He's supposed to be on his way.
Yeah, they're trying to dress him out because they haven't seen it.
Well, I was really hoping that Miss Jordan was going to kind of be a part of the hearing. I know she has sent both Miss Curry and myself, I'm assuming you as well, Mr. Schmidt, of quite lengthy email regarding her strongly worded opinions on how the cases are being handled, about her son's mental health. And so I was hoping to have her be a part of the solution. I'm not sure. I have an email from March 26th at 9:48 a.m. But I see that it was sent to Miss Curry and myself directly.
This is March 29th.
Yeah. She said to me that she wanted it to be her official victim statement, so we put it in as a victim impact.
Okay.
So that's.
All right. And let's see, I'm waiting for Mr. Krill. Good afternoon, Dr. Corman. Can you see and hear me okay? I think you're on mute.
I'm sorry, Your Honor.
Okay.
Good afternoon, Dr. Corman.
Hello.
Mr. Krill on his way?
Yes, Your Honor.
Sorry for the inconvenience, Dr. Corman. Be just a moment. We're going to get Mr. Krill up and try to get going.
No problem.
Now, Mr. Craig, we're giving it.
All right, court is now on record in cause numbers 2000. 25-92, 2025-98, CR 24-206, State of Texas versus Brandon Ashley Krill. We have a couple things set today. We have the state's motions to dismiss, request for a personal bond, and we also have the application or the order, request for an order to assess psychoactive medications, regardless of patient refusal. And so we have Dr. Corman here, ready to testify, if need be. I think first, let's take up the state's motion to dismiss, and hear the basis of that, Ms. Curry.
Sure. Your Honor, I have had many of email conversations and telephone conversations with Cindy Jordan, who is the mother of the defendant and the victim in every offense. The offense he is currently on probation for with the revocation for motions for adjudicate pending, and the new offenses, she's the victim in all of those. I have had many personal dealings with her about this and many conversations. I have told her my opinion as to what is best for her son, let me back up. What is best for her as the victim in the community in this case, and how that is juxtapositioned to what might be best for her son's mental health treatment. I have explained in great detail to her my fear for her if her son is released from incarceration, from jail. However, I have responses from her both in writing and verbally that she will not testify in these cases. I've explained to her that could mean that a court at some point finds her in contempt if she fails to testify. She bears great guilt for the position that her son is in. I have explained to her that she should not bear that guilt, that this is not her fault. However, she cannot get rid of that guilt. She has literally begged me to dismiss these charges. I was very, very much against that at first, because 36 years in this business, I've seen this progression before, and I think it continues to progress. However, I also know from the practical side that the only person he has ever victimized is her. He's never been a danger to the other part of the community, and that if she does refuse to testify, I cannot meet my burden of proof of proving these cases beyond a reasonable doubt. I am confident that she will communicate to her son once he gains confidence that she will not testify, and therefore I would expect that he would not enter any kind of guilty. So I am in the position, or I was in the position of having a hearing to force medication to get him competent, knowing that then the only case I could proceed on would be potentially the revocation, because I can prove that by that time without protesting. So I prove up revocation. He's got 2 years credit. Virtually no matter what we do on that revocation, if we do something in line with what normally happens on a revocation like that, he would be immediately paroled. If we extend him and put him on the mental health caseload, he would be potentially kicked out of the jail door with nothing, including no place to live. When I took the time to evaluate all of those factors and the fact that this woman is the only victim, is begging me, is crying because she feels like she's put her son where he is, and that she's contributed to his decline, because if he wasn't where he is, he could have gotten medication more readily, been more open to taking medication. When I considered all of that, Judge, I determined that, in my opinion, the interest of justice would be served if I filed motions to dismiss on the new offenses where she is the victim. If I did not get rid of the revocation, and I consulted with Ms. Burns, the head of the probation department, and she agreed that it would be better not to just withdraw the motion to adjudicate on his probation, but to give him a PR bond on it, so that he can go to the inpatient facility at the Terrell State Hospital, complete that there, and then be on the mental health caseload with a modified condition that he take his medication and that he continue his outpatient counseling. Initially, Ms. Jordan had represented to me that Terrell had committed to keep him long-term. When I called to verify that, the issue I ran into is that the doctor who was assigned to Brandon Creel last time Brandon was in Terrell is no longer employed there. The last time Brandon Creel was there, he stayed through their 90-day program. That doctor is no longer employed there, so no one there was willing to give an opinion that, yes, he will stay in this program, whether it be the 3-day program, the 14-day program, the 90-day program, or the 1-year program. I was comfortable enough after talking to the admissions people that, and from knowing how it works from my office representing the state in mental health proceedings, I was comfortable knowing that when a peace officer's warrant is done to take someone to Terrell, there is a first hearing that happens within 24 to 48 hours. There is a second hearing then at the end of the first 72 hours, or 72 hours after the first hearing. The next hearing after that is a 14-day hearing, and then a 90-day hearing, and then a 1-year hearing. Knowing how all that works and learning about how long it will take for these medications to take effect, I was comfortable enough with the fact that we would at least get into the 90-day program, if not the 1-year program, before Mr. Creel regained confidence. My hesitancy for medicating him in the jail and making him confident again is that then I don't have the tool to get him to Terrell State Hospital beyond just the first 72 hours, because if he is confident, when he is confident, he is not a danger to himself or others. The only way to keep him in Terrell, where he gets not only medication but also therapy, is for him to go there in a bad state, off his medication. It's not so much that they worry about legal competence or incompetence, but their standard is danger to himself or others. So the only way to get him there and then be able to keep him on their standard that I could think of was to do it prior to medication. That's why I filed motions to dismiss and the motion for PR bond, so that he would go to Terrell, be there more than 72 hours, and then become competent. We can modify his probation, give him a condition that he continues outpatient treatment, he's on the mental health caseload, and is required to take the medication prescribed by Terrell. That's still the position of the state, John. That's the best thing to do here in the interest of justice.
Mr. Schmidt, do you want to be heard on that at all?
Just a bit, Judge. When I first met, I guess she was almost 3 years ago. I knew that he had issues with mental health. At the time, I had no indication that he was incompetent or that he posed a danger. So we flagged to the probation bureau. On the new offenses, obviously, he was off his medication, and all the indications that I had was that, his mental health was acute to the point where I don't believe that he was responsible for his actions. We did file a notice of intent to seek the insanity defense on those issues. I think the court's also aware that, at a certain point in time, our request funds for a forensic examination for that purpose. However, in the interim, he continues to deteriorate, refuses to take his meds, and ultimately that insanity evaluation can't take place until he's restored. At least that's what the experts told me. So we have to restore him first, and then do the evaluation to determine whether he was insane, legally insane at the time of commission offenses. So unfortunately for me, I'm in a position where I know that Mr. Krill, chose not to take his meds voluntarily. And I can consent on his behalf, obviously, but because he is incompetent, I also, I don't feel comfortable communicating with him as far as what he believes is in his best interest. I can tell you also, Judge, that the statements made by Ms. Curry pertaining to the alleged victim in this case are all, I've received the same communications with her. And she has reiterated to me, and I'm sure she has to Ms. Curry over and over and over, that she does not believe that Mr. Krill should be incarcerated, but that he needs mental health treatment. And I think under the circumstances and with all the information we received from the jail and my meetings with him, it's blatantly obvious that, you know, without some sort of long-term mental health treatment, we're just going to continue, you know, on revolving door with the issue. So if the court grants the state's motion to dismiss new offenses, it makes the insanity notice new, so that we do not have to retain a forensic expert for those purposes, and we can move forward. I would say that from my perspective, representing Mr. Krill, that really concerns me. I believe that once he's medicated, he does very well. I think that so long as he stays on his meds, he can be successful, completing his term of probation, and that's pending on the MTA. But he has to, if he doesn't stay medicated, then he deteriorates quite quickly. So I would kind of, you know, in a roundabout way, concur with Ms. Curry's assessment. And I think that as far as long-term solutions are concerned, he's always lived with his mother, and mother loves him, but ultimately in his current state, he doesn't really need anywhere. And so in order to get him a place to live with the successful motivation, I think that's the option to add. We would draw the state in essence, the court grant those motions to dismiss as well as the PR law, so that we can begin that treatment process.
Here's the court's concern that I want you to address. And Mr. Schmidt, you mentioned it, a revolving door. This is not the first time that we've dealt with these exact issues with Mr. Krill. And Mr. Krill was suggested as incompetent. Court expended taxpayer funds to have him evaluated. He was found incompetent. Dr. Corman came and applied on behalf of the Mental Health Authority, evaluated Mr. Krill, found that he was unable to, make a rational decision and would continue to deteriorate, would be a harm to himself or others without it. And the court granted, after hearing the court-ordered medications, and Mr. Krill was given those medications against his will. I find that even though the order was there, that Mr. Krill was voluntarily taking them because he knew that the order was in existence, and I don't think that they had to be forced upon him, is the communications that I've had with the jail staff. And not long after that, within less than 60 days, Mr. Krill was restored to competency and was removed from the clearinghouse list that he was placed on with the state hospital. And it was at that time that he restored to competency that the plea agreement, I believe, was reached, and he was placed on community supervision. So my concern is if I grant the state's motions to dismiss and give him a personal bond and let the jurisdiction take him to Terrell State Hospital, there's no guarantee that Terrell State Hospital is going to keep him at all. And if they don't, he's got nowhere to go. We know where he's going to go. He's going to go back to his mother, Cynthia Jordan's house, and she is going to call 911, and he is going to be arrested, rearrested, and he's going to come back to the Van Zandt County Jail, and we're going to start this process all over again. And we're going to continue to spend taxpayer money day after day. We're going to have to reevaluating for competency. We're going to have to try to determine if he's going to have court-ordered meds. And we know that when he gets court-ordered meds, he restores quickly. And then we have an opportunity, I believe, to get to that point today, because we're scheduled for the hearing today. If we don't, if I grant these, Dr. Corman doesn't testify today, the psychoactive medications are not applied, Terrell State cuts him loose in 24 hours or 72 hours or 14 days or 20 days, and he's on a personal bond. He's back in the community where no place to go. He's going to go to his mother's house. And I understand that that the argument about Miss Jordan and what she's feeling as guilt and these things, but the fact of the matter is she's the named victim in every one of his cases. And the case that's before this court alleges that he attacked her with a hammer to her head. And so I don't take that lightly. I'm afraid that this woman, her love for her son, is going to put her in a position to be just wearing the DA's office out about getting the case dismissed. And if he gets out without any type of medication, and he's incompetent or he's insane or what have you, and he kills her, then I think her blood is on our hands. I really do. I think the three of us sitting here, the blood would be on our hands if she is killed. And so I am concerned that in addition to the just throwing good money after bad, to have to, as a revolving door, continue to throw this money at reevaluations and hospitalizations when there's no guarantee that we're going to be able to do that. I'm not aware that Terrell State Hospital is going to be able to get him the help that he needs any faster than we're doing it today, because he's going to go over there and he's not going to take his meds. And when he doesn't take his meds, they're going to have to go through the court process to ask for court-ordered medications. And we're already here today, ready to do that. Now, with all that said, I understand the position of the DA's office. And so it's going to be really your decision, Ms. Curry. I believe the ball is really in your court on whether or not you want to continue prosecuting the cases. If you don't, then there's no sense in Dr. Corman being here today and testifying. If the DA's office does not want to pursue the cases, then I think you're in the position to say so. And I'm not going to require you to seek psychoactive medications if you don't want to, and Miss Jordan doesn't want it. I'm just saying that if this revolving door continues, then everyone's on notice about the potential consequences to the safety of the victim and the consequences of continuing to make decisions regarding the use of taxpayer money to try to get some kind of mental health help for Mr. Creel. And I've referenced the emails and the letters that Miss Jordan has sent, and I understand she's very frustrated. And one of the comments, that she says is, this county does not have a system that supports mental health at all. Well, I would strongly disagree with that. I think we've been trying to, all three of us and more, have been trying to help her son for the past several years. Obviously, she's not gotten him any kind of mental health treatment, so she's left it to law enforcement to do it. And I know our system is not set up. The criminal justice system is not set up to deal with mental health. That's not the primary goal of the criminal justice system, but it is a responsibility that we take upon ourselves and that we have to carry out. And I believe that we're trying to do that to the best that we can with the resources that we have. But at this point, I think the ball is in the state's court, and you get to decide today, Ms. Curry, whether we hear from Dr. Corman on whether or not he believes psychoactive medications are required, whether or not he gets to competency, whether he stays in custody, or not. Mr. Schmidt.
One of the things that frustrated the process, I think, especially with the Jordan, is the initial offense, which got Mr. Creel on probation. I think at the time You'll understand why that happened, and I'm comfortable with this plea, at least at that time. I think that the subsequent cases that pop instead could have been avoided. I think Miss Jordan would have sought an emergency detention for mental health evaluation rather than being arrested for. So one of the issues that I've had is it's ongoing with not just Mr. Creel, but with multiple individuals, is that someone's had an acute mental health issue, they're known to have mental health issues, and ultimately the family calls law enforcement and lets that law enforcement agency know that the individual has acute mental health issues. But it's very inconvenient for them to take someone to the hospital for evaluation because the officer who does that has to sit on them. So rather than do that, in these acute situations where an individual is known to have severe mental illness, they arrest them. And so no matter what we do, if the state dismisses the newer cases, I understand if they choose not to dismiss the cases, then it's still our position that Mr. Crew was insane, legally insane at the time. So when we look at the revolving door and the expense to the taxpayers, that expense is gonna happen, whether it happens on the front end or the back end, because I mean, I can't price the forensic expert, but I have to go through that due diligence process, and it is a sheet. And so when I mentioned the revolving door, I agree with the court's assessment. However, I think that some of these issues have been exacerbated by the fact that instead of being taken to a mental health facility, he was placed in a jail. And so our position is that I don't believe that he's legally culpable for the numerous indicted offenses anyways. I cannot state to the court that I believe he was incompetent, otherwise I would have planted on the first one. We go up to this process back, but I think one of the things in the discussions I had with Jordan was his current status, in that I understand that she lost and she wasn't protected, but he doesn't need to be at her ass. I think she understands that. At least we've had those conversations where, you know, she would relate. She understands that in the current state that he needs treatment. But my hope actually for him is that if he gets the jail state, gets out of the jail system and gets that treatment, that we can move past this eventually. But in the path we're on right now, it's more likely than not that he's going to be sitting in Nantucket County Jail longer while we attempt to get the evaluations done, get the forensic reports done, and move forward on the legally indicted cases. So when I look at it, you know, best case scenario, he gets treatment, he stays on his meds, and everybody's happy. Understanding the court's concern, but I think that based on understanding and talking to the story, you know, most of their issues are arguments, and even when he's on probation, but I don't think that he can actually solve. I'm sorry, it was discrimination, so I don't know, was it a friend?
On the new one?
No, I think it was a friend, and so, you know, so far as I know, based on my conversations with Mr. Stewart, he is not injured there, but because of his mental health issues, and, you know, she's, I guess, roughly 90, so I'm gonna blame it on this, you know, but I think that based on that dynamic, she is incapable of directing him one way or another. So, long story short, I understand the court's position, but I think that the only real logical path going for Mr. Riddle and the taxpayers is to get him to treatment. And I guess we could say we hope for the best, because that's all we ever do is hope for the best. But the alternative, I don't think it's going to look huge.
But my question is does he need mental health treatment if he's competent?
Yes.
Okay.
Absolutely.
And so he's been getting mental health treatment the whole time he's been on community supervision? No, that's caseload for probation. Is he on mental health treatment? Is he actually seeing a provider and getting treatment while he's on? No. While he's on community supervision before he got the motion to revoke.
I believe he was supposed to be. I think that was a condition.
I know supposed to be, but was he? All right, because I don't want to split hairs on words, but they're going to have to get him competent, right? the Andrews, or not the Andrews Center, Terrell State Hospital is going to have to get him competent at some point in their treatment.
And they medicated and theoretically, based on his historical results, he would become competent.
And I would say not necessarily legal competence is not their concern, safety of himself and the community is for concern.
So let's just make an assumption that Terrell State's able to get him safe within 14 days and they send him out and they send him back to Van Zandt County. And he decides he's not taking his medication anymore. And now he's out on a personal bond on aggravated assault with a deadly weapon. And he's in the community. And he's the only person he knows is the person that calls the police every time he comes around. And I know that she wants to blame the DA's office. She wants to blame the court. She wants to blame you, Mr. Schmidt. But she's not, to my knowledge, done anything to seek mental health treatment through Terrell State or a guardianship or anything of that nature. It's just call the police officers, let the police officers deal with it. And they've dealt with it. And unfortunately, we're now in the criminal justice system having to use what mental health resources we have available to us, vis-a-vis Dr. Corman, Mental Health Authority, application for psychoactive medications to get him competent to determine whether or not he was insane when he committed these alleged offenses, or was he not? If he was, or if he wasn't, then obviously disposition of the criminal case or continuation on community supervision. I'm just not as confident as the two of you that Terrell State, because they're not here in the community, and Mr. Krill's case is going to be one like many others, and they're going to get him to a point where they feel like he's safe, and then they're going to put it back upon him to maintain. And the three of us know that he's not going to maintain because he hasn't maintained. And so I think the victim, the safety of the victim, the safety of the community, I think that's why that's in the forefront of my mind. I'm not trying to say that I can see what's going to happen in the future, but I'm willing to make a really strong financial bet on it. And so like, it goes back, Ms. Curry, I think, to what do you want to do on your criminal cases? Because I'm not going to make Dr. Corman testify and do all these things. And obviously I can't make you say, yes, Judge, we want to do this. We want to get him competent so that we can, help him in his current state in the jail. If you don't want to go forward on that, then I guess that I want some kind of assurance that when this happens again, I'm not going to continue to see cases being filed, and then he becomes the jail's problem, and then he becomes the court's problem, and then I got to continue spending taxpayer money to go back and do the same thing that we've already done time and time and time again.
Very strong. And she told the police, asking them to take her son to Terrell State Hospital, not to take him to jail. He was hiding under a blanket in her backyard. He had gone inside the house while she was gone, taken a blanket, taken it outside, and he was hiding under the blanket in the backyard when the police arrived and charged him with burglary and criminal trespass because he wasn't supposed to be on the property.
And so let me interrupt. So, but your office filed indictments on all of those.
Did the exact same concerns that we filed, and we sought an indictment based on how that was written in the police report without talking directly to her ourselves, like we've done now. I don't think it's unusual for a DA's office to proceed in that case based on the police report. But I understand, because it is always such a concern in Van Zandt County about our limited resources and spending taxpayer dollars. I understand that. But it is an unfortunate reality that there are just people in this world who were not blessed the way those of us in this room were, to be free from mental health, from debilitating mental health issues. And it is our responsibility as human beings who have been blessed in that way to take care of those who have not been. I believe that. So while I understand the financial argument, in my mind, it is not the foremost consideration. I'm standing here as a prosecutor sworn to do justice, along with all of the other responsibilities and disclosures and other things that are now incumbent on prosecutors. I know that I have the new cases that I don't believe I can win in trial because I don't have a witness who will testify. I firmly believe that lady will go to jail and sit there before she testifies against her son because of the guilt she's experiencing. Mr. Schmidt may be right. He was insane at the time of the offense. We could spend a whole lot more tax dollars to find that out and then let him sit in our jail for 18 more months while he's on the list, waiting to go to a state hospital for insanity. Or we could try getting him some treatment. I've done that balancing, I've done it, I've spent hours on it. I believe that the right thing for me to ask the court for is to try the treatment. In that regard, Your Honor, my ethical obligation, I believe, is to ask the court to dismiss the new cases. If I'm sticking to my ethics, which is what I'm here to do, I know that I can, and I believe that I can, prove the probation violations without dispute. So if I'm making this based on the ethical considerations that I'm bound to as a prosecutor, then I will ask the court to grant my motions to dismiss on the new cases. I will leave the issue of the personal recognizance on to court. I will say, Your Honor, it's my understanding that on the violation of the court to the DA's office and on the state's motion to revoke, there were no conditions alleged that he had violated regarding his mental health treatment.
Well, let me, before you sit down, so if you're leaving the motion for personal bond to me and I say, or personal recognizance bond, and I say I'm not comfortable with it, it still leaves us in the position that you've got to make a decision. Because if I say I'm not comfortable with that, I'm not comfortable cutting him loose and letting Terrell State Hospital decide when he comes into the community and when he doesn't, whether they service him, whether they don't, you're still going to be in a position to determine whether or not you want to go forward with this application for court-ordered meds that I think Dr. Corman's going to recommend that he needs. Because if I say no to this, then he's just going to be sitting in the jail with nothing, with no competency restoring psychoactive medications, no ability, no mental health treatment whatsoever.
Plus psychoactive medication without the state.
Well, I think it's clear the court does not agree with a personal recognizance bond for Brandon Creel. Court will grant the state's motion to dismiss in cause numbers CR 24206, court signing an order reflecting that ruling. Court is granting the state's motion to dismiss in cause numbers 2025-92. Court is signing an order reflecting that ruling. Court is granting the state's motion to dismiss in cause number 2025-98. And the court is signing an order reflecting that ruling. Court is denying the state's motion for personal bond and cause number CR 23158. Dr. Corman, are you still there and available? Dr. Corman, you're on mute. And Dr. Corman, can you see and hear me okay?
I can't. We had to switch computers. I'm sorry. The computer went down.
It's okay.
Can you hear me?
Yes, I can hear you. Can you hear me?
I can.
Okay. So, all
Yes.
right. So, Dr. Corman, I know that you were present for a large part, probably not all, of the hearing that was held with regard to the state's request to dismiss charges against Mr. Creel and to grant him a personal recognizance bond, meaning allow him to post a personal bond where he could walk out of the jail and then go to Terrell State Hospital. Were you present for most of that hearing?
I was. I understood the issues, but I don't know the conclusion.
Okay, so the court has granted the state's motion to dismiss the new charges, which I believe were a criminal trespass of a habitation, I think, or burglary of a habitation, criminal trespass, criminal mischief. But the court has denied the state's motion for personal bond. And Ms. Curry wants the court to consider the application of court-ordered medications by the court on its own. So I don't think that she'll be asking you questions today or attempting to prove up your application. So at this time, what I would like to do is swear you in and get your expert opinion. If you'll raise your right hand. Dr. Corman, do you swear that the
Yes.
information, you swear that the information and testimony that you provide to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, thank you.
Yes.
And Dr. Corman, can you go ahead and state your name and occupation?
David Corman. I'm a physician specializing in psychiatry.
And Dr. Corman, who are you employed by?
The Andrews Center.
And is the Andrews Center the mental health authority for Van Zandt County?
Yes.
And as the mental health authority for Van
It
Zandt
is.
County? Okay, I'm sorry. There's a
Yes.
delay. There's a delay, and so if I give a moment before I say anything, it's because I'm trying to anticipate that delay.
Yes.
Dr. Corman,
Very well.
Dr.
Yes.
Dr. Corman, as the mental health authority for Van Zandt County, is it part of your responsibilities to interview individuals that are suspected of having mental health disorders at the Van Zandt County Justice Center?
Yes.
And have you interviewed and conducted an assessment of Mr. Brandon Ashley Creel?
Yes, I have.
And you've done that on more than one occasion, is that true?
That is true.
And can you tell the court when is the most recent time that you have evaluated Mr. Creel?
Yes, I saw Mr. Creel. They actually brought him to the office on March 16.
And so you interviewed him there at the Andrews Center here in Canton, Texas?
Yes, I did.
All right. And can you tell me about that assessment and any conclusions that you've made?
I found he still meets criteria for the diagnosis of schizophrenia, that he's actively psychotic, and that he would benefit from medication and from a court order for medication.
Do you believe that Mr. Brill possesses the mental competence or capacity to make a rational decision as to whether or not to submit to mental health treatment or medication?
I do not believe he possesses that capacity.
And in a previous evaluation, you made that same conclusion back in 2024. Is that correct?
Yes,
And Mr. Creel back in 2024 was subjected to mental health medications involuntarily. Is that correct?
yes,
And in 2024, Mr. Creel, after the administration of those medications, became competent. Is that correct?
yes. He improved significantly, and I understand he was determined to be competent.
Do you believe that that is the same possibility for Mr. Creel here in 2026, or are there any circumstances that you think are different?
No, I think the likelihood is that the same thing will happen.
And what classifications of medications do you believe would be necessary for Mr. Creel?
We're requesting antipsychotics, antidepressants, anxiolytics, and mood stabilizers.
And how would you recommend, if at all, those would be administered, excuse me, to Mr. Creel if he did not take them voluntarily?
If he refuses, then I would recommend he receive them intramuscularly.
Are there any other recommendations that you are making to the court today?
No,
Do you believe that Mr. Creel, without the administration of psychoactive medications, do you believe that he poses a harm to himself or others?
I do.
Right. Mr. Schmidt, do you have any questions of Dr. Corman at this time? No questions. Ms. Curry, any questions? All right, then the court is going to find that on the testimony of Dr. Corman, and the court takes judicial notice of his application for court-ordered mental health medications, that Mr. Creel meets the required criteria for the administration of psychoactive medications, and the court hereby grants the classifications of medications as included in the application of Dr. Corman. Court will sign an order reflecting the ruling for that administering of the psychoactive medications involuntarily should Mr. Creel not comply with the court order. Is there anything else, Dr. Corman, that you would like to add on Mr. Creel's case or think would be relevant for the court or for the attorney for the state or for the attorney for the defendant to know?
No, I think this is the best outcome in the best interest of the patient, really.
Do you, Dr. Corman, were you able to hear, and there might have been some audio difficulties, were you able to hear Ms. Curry? Were you able to hear Ms. Curry at all when she was making the argument about seeking mental health treatment at Terrell State Hospital on a release and admit? Do you have any opinion on that?
Well, I was able to hear most of that, and I think that the concerns I heard you voice that he might end up back out of the hospital, refusing meds, and be once again psychotic are valid concerns.
Okay. Anything else?
That risk would exist.
All right. Thank you, Dr. Corman. Anything else?
No.
All right. Thank you, Dr. Corman. I appreciate you being here today. Sorry for the delay, but there was some procedural issues that the court needed to take up before we got to your testimony. So sorry for any inconvenience upon your time. Thank you for the work that you do, and thank you
No
for being
problem.
here today.
Okay, I think am I to testify in another case?
Yes, I think Miss Cormier potentially, is that correct? And Mr. Manning,
Yes,
are you
Judge.
are you ready? And let me see. Yeah, Miss Cormier's there. All right. Let me call that case. Let me move some papers around so I can make. I do also, before we get to Miss Cormier's case, I do want to place on the record. I know that Miss Jordan has made some statements that Brandon is not even on a waiting list for a bed for restoration. I want to correct the record on that Miss Taberham has updated that he is number 178 on the restoration list as of yesterday. So Miss Taberham, as the criminal court coordinator, has been working diligently with the Van Zandt County Sheriff's Office, their nurses, the medical staff there, and the Andrews Center and the state hospital in trying to ensure that Mr. Krill, should he require long-term hospitalization for competency restoration, that his case is being admitted and that he is being moved up on the list. So I do want to give Ms. Jordan that assurance that we're not, quote, treating him like an animal and locking him up in a cage. It's not true. So we will continue to keep him on that list. Hopefully the psychoactive medications will do their job like they did in 2024. Hopefully Brandon doesn't require long-term commitment for restoration, and that would therefore no longer be an issue. So I'm going to remain hopeful and positive on that accord. All right, so moving on. The court now calls cause number. Oh, I'm sorry, it's unindicted. So this is an unindicted case, and this is in the matter of Nicolette Cormier. And Mr. Manning, are you ready? Mr. Manning, are you ready?
Yes, Judge.
All right. Mr. Hartwell, you ready?
Yes, Your Honor.
All right. And Dr. Corman, I've already placed you under oath in a previous case. You understand that your testimony is still under oath?
Yes, sir.
All right. Mr. Hartwell, would you like to proceed?
Your Honor, if I could defer to Mr. Manning on this one and follow up if it becomes necessary.
Okay. Mr. Manning?
Judge, it's my client's position that she doesn't need the medication. Furthermore, Judge, she doesn't recognize me as her attorney, but has stated that she has an attorney out of Louisiana that she wishes to represent her. I have not been able to contact that attorney, but I can, based off of the application that was provided to the court on her behalf, state that she does not want medication to be administered to her against her will.
Understood. And the court does not find that any other counsel has filed a motion to substitute, nor have they filed a motion for appearance. So the court does not recognize any other attorneys representing the legal interests of Ms. Cormier. So Dr. Corman, you filed an application for order to administer psychoactive medications. Is that correct?
Yes.
And in that application, you indicated that that Ms. Cormier is she currently subject to an order from either January 29th of 2026 for court-ordered inpatient mental health services under 46B?
Yes.
And I believe that you've made a diagnosis of Ms. Cormier after your evaluation. Is that correct?
Yes.
And what is her diagnosis?
Schizoaffective disorder, bipolar type.
Okay. And you've also given your opinion that the patient lacks the capacity to make a decision regarding the administration of psychoactive medications. And what was your reasoning for that opinion?
I documented in the application that she's delusional, grandiose, paranoid, has delusional denial of illness and incapacity to appreciate her legal situation due to her poor reality contact.
Refuse medical care. I'm not
Yeah.
interested in diagnosis.
And Dr. Corman, you did this evaluation on March 10th of 2026 here in Van Zandt County. Is that correct?
Yes, March 10th.
And was that conducted at the Andrew Center in Van Zandt County, or was
Yes,
that?
it was.
It was, okay. And if Miss Cormier is ordered to take these medications, what do you believe the prognosis would be?
Well, I believe it will be more favorable, that her psychosis might resolve and her insight might improve and her capacity to assist her attorney in her defense would be restored, would be the greater likelihood.
And if Miss Cormier refuses to take the medication, what would be your recommendation about how they're administered?
Well, I wrote orally, and I did not write if refused on the document. I failed to write intramuscularly if refused, but perhaps I should have.
Would that be your recommendation if she refuses to take them orally?
Yes.
Okay. And what classifications of drugs specifically are you asking the court to order for Miss Cormier?
Antipsychotic, mood stabilizing, anxiolytic, and not antidepressant, just those three: antipsychotic, mood stabilizing, and anxiolytic.
All right. Is there anything else regarding your evaluation of Miss Cormier that you think would be relevant or important for the state, defense, or court to know?
I checked the box that indicating that she lacks capacity to make a decision regarding administration of medication. I did not check the box stating that she was a danger to self or others. So I guess I would have you make note of that.
Yes, sir. Mr. Hartwell, any questions on behalf of the state?
None on behalf of the state, Your Honor.
Mr. Manning, any questions for Dr. Corman?
Judge, I do have a couple questions, as well as it appears my client was trying to relay some information. If I may have an opportunity after I ask my questions to speak to Ms. Cormier in a breakout session to make sure that all her questions are answered regarding this hearing.
Yes, sir. I'll grant that. I just did not want Ms. Cormier to interrupt the testimony of Dr. Corman, and if she's trying to talk right now, obviously, and so I don't want to get into a position where I'm trying to hold a woman who may be suffering from mental health in contempt of court. So yes, I will put you in a breakout room where you can talk to her, and I'd be happy to have you relay everything that she wants said.
Thank you, Judge.
Go ahead, Dr. Corman.
Dr. Corman, were you able to take a full and accurate psychological and physiological history of my client?
I was. We spoke for the better part of an hour.
Okay. And how did you gather that information? Was it from self-reporting or from other sources?
Primarily self-reporting.
Okay.
I did have access to records from previous psychiatric hospital admissions in past years, and I took notice of that as well.
And does my patient, or does your patient, my client, have any allergies or negative side effects or reactions to the medications that you're proposing to administer?
Not to my knowledge. She did not indicate that she did.
Okay. But so are you telling the court that we are relying on Ms. Cormier's self-reporting of her medical history to determine whether there be any contraindications for the medications to be administered?
Well, there's that, but also I have records from her hospital admissions about what medicines she was discharged on and tolerated in the past. So I know she's not allergic to those.
Okay, so we have previous administration of these medications that seems to indicate would be safe or effective in her treatment.
That's right.
Okay. And just one point of clarification, I see at the top of the application, it says that Ms. Cormier was the applicant and a MD, but that's actually not.
Oh, I'm sorry. Yes.
Okay.
Her name's there and it should be my name.
Okay. I just want to confirm that she's not requesting medications, nor is she. Okay.
No, that's an error.
How has my client expressed her desire not to take her medication?
She was very adamant and vociferous about her belief that she does not have a mental illness and that she does not need medications, and that medications do not benefit her. And she would not acknowledge to me that actually that she'd ever specifically been on medication, but or ever been in a hospital. But I discovered that through records.
Okay. What less intrusive methods have you attempted to have her take her medication?
Well, I would gladly offer her medication if she would consent, but she, again, feels very strongly against medication. And I felt as though she was making it clear that for her to consent to medication would mean she was agreeing she had a mental illness, and she disputes that.
Are there other reasons why someone would reject medication other than being diagnosed with a mental health illness?
Well, they could have other beliefs about how they might get well, or they might have fear of potential side effects. I guess there could be reasons that people opt not to take medications when they have the freedom to do that.
And would you say that it is very we are overruling an individual's autonomy when we're requesting a court to administer medication against their wishes?
I guess that's an accurate statement.
Okay. Your Honor, at this time, if I may speak to Ms. Cormier and just see if she has any further questions for me to ask Dr. Corman.
Yeah, just a moment. Dr. Corman, I think I failed to ask you, prior to you evaluating Ms. Cormier, was there any other information that was relayed to you from the Van Zandt County Justice Center, from the jail, as to her behavior that is what got your interview with her? Obviously, you just don't show up at the jail and interview people.
No, I don't. And she actually was brought to me here at the Andrews Center. I was aware from an email from the liaison from the Andrews Center to the jail that she was in the jail and that it was coming for an assessment. But I'd had no other information ahead of time about her condition.
All right, but there is a liaison that you've indicated that is there at the Justice Center that communicates mental health concerns from the Van Zandt County Justice Center to the local mental health authority.
Yes.
Is that the customary route that people who are suffering from mental health issues or disorders or experiencing some type of either physical or mental deterioration are then brought to the local mental health authority to determine whether or not there's a better way of treating or whether or not someone needs treatment?
I think that's customarily where it begins, that the liaison makes us aware and gets her on our schedule.
And does that happen quite often here in Van Zandt County?
It happens, occasionally, fairly often, but not every day.
Okay. All right, then, Mr. Manning, what I'll do is I'll take all that under advisement. I will put you in a breakout room with Ms. Cormier. So I think she's trying to tell you something right now. So give me just a moment, and I will direct there in the court, in the jail court, if you will accept the breakout room request so that Mr. Manning can speak with Ms. Cormier and then return back to the main session once you're ready. Is there any objection or opposition to Dr. Corman being finally excused?
None
Judge,
from the state, Your Honor.
my client may have some questions of him, so I'd ask that he be held just briefly while I speak to her.
Okay, Dr. Corman, should just be a few moments. If you want to, you're welcome to mute and turn off your camera, and then I'll summon you back if needed.
Okay, very well.
All right, thank you.
Thank you.
All right, give me just one moment. I'll set up that breakout room.
Need your input. I'm an MSW and I work with people like you in the field of mental health.
Give me a moment and I'll move her over there.
Judge, I'm back. I don't know if the jail screen's back yet.
All right. All right, Mr. Manning, anything further for Dr. Corman?
Judge, other than my client's strong feelings about not having medication administered forcefully, there was no other questions for Dr. Corman.
Mr. Hartwell, anything further for Dr. Corman?
Nothing, Your Honor. Thank you.
All right, Dr. Corman, thank you for being here. You're free to go. Appreciate you.
Judge, there was another matter that my client wished to take up, and I relayed to her that I would, on her behalf, let the court know that she has once again told me that she wishes for me not to represent her, and that she will not work with me in representation of her going forward. I believe her words were that I was fired. So she has also additionally requested that she represent herself. I have not had the ability to do in my previous and current representations. I've not had the ability to assess whether or not she would be able to represent herself, but that is her request at this time, is that she represent herself.
All right, court understands Ms. Cormier's position. The court finds that you were not retained as counsel. Correct me if I'm wrong, Mr. Manning. You were appointed to represent Ms. Cormier.
That's correct, Judge.
All right, court finds that you were not retained. Therefore, Ms. Cormier cannot, quote, fire, quote, you. So the court denied that request. The court does not find that she is in a mental state to be able to represent herself at this time. And so that is denied. And the court hereby grants the request and application for order to administer psychoactive medications based on the testimony of Dr. Corman. And the court will authorize the psychoactive medications as identified in the application for antipsychotics and anxiolytics, sedatives, hypnotics, and mood stabilizers. Court will sign an order reflecting its ruling and provide that to council.
Thank you, Judge. May I be excused.
Yes, thank you, Mr. Manning. Hope you feel better.
Appreciate it.
Okay, Your Honor, we will get the others in here momentarily.
All right, let's take a 10-minute mental health break, and we'll be
Okay.
back at 2:55.
Okay.
Judge, you're gonna be working on the speaker.
Yes, sir. Thank you.
Mhm. We just want to.
Wayne, can you hear us?
What do you need?
Oh,
Oh, you're just
Yes, I can hear you.
So
I'm going to be at the bench. Yeah, your audio's good, video's good.
when you go to speak, it needs to be on that AI speaker.
okay, we just didn't have, we had the speaker on the TV on and not the other one, so now it's on.
So the
So
D40F,
that was the reason you were having difficulty hearing?
Yes, sir.
The D40F, that's the TV. You need to be on that where it says AI speakerphone.
We just couldn't mute you.
Now it works.
Mr. Smith,
Can you say something, Mr. Smith?
so I think what's happening with them is that they're picking up the ambiance from the bench microphone and not this microphone here. I don't think this microphone is connected, because he should be.
We could hear it in the courtroom, but we just couldn't hear it.
No.
We've already tried it this morning. We were having.
Richard, can you say something from that point right there?
Yeah.
There you go.
See what I'm saying? I think he's picking up from the bench microphone and not the microphone on the.
Sitting on the desk.
I think, I'm not there. so-
Richard, can I trouble you to go over to that microphone and say something close to it, please? Because you're getting picked up from the other one.
Let me do it. Richard stepped out.
Oh, okay. I'm sorry.
Give me just
Judge
yeah,
Mark,
give me
you're
just a
good.
moment.
Judge's
His
mic is,
audio is booming.
yeah, this is booming. That one should be picking up better.
Yeah.
Mic test on council table. Mic
test
on council table.
Yeah, that's fine. Sound.
Yeah, we can't.
I think they're picking up the audio, the microphone on the bench is picking up. Yeah, I don't think that microphone.
Those mics aren't picking up. It's your bench that's picking up everything. It picks up inside the courtroom. We tried it earlier, but when you talk, the noise is coming from the other, from your bench.
From your microphone, I guess on your computer or
Well, you get up here. All audio is routed through the laptop here. All routed.
Yeah, see now you're booming. Now you're really
so
loud.
there's not a microphone that goes from his laptop back to those microphones. I'm sorry, there's not microphones from the audio.
You're asking.
The audio
Well,
from
we
those.
can't, no, the microphones in the courtroom amplify the
Yes.
courtroom and it's picked up by my laptop.
There you go.
Otherwise, we'd have a constant sound loop from each
No, that's what I'm saying.
laptop.
So when you click on the audio here on the Zoom link,
Okay.
it actually needs to be on that AI.
Patty, you see
speakerphone.
that? In case I'm not here.
So this is actually, here's your computer audio here. And this is the audio from Zoom.
You go to the AI,
So make sure that you're selected on the AI speakerphone.
because we were on the TV, which is the one above it.
Yeah.
Thank you, sir. Found it.
You're welcome.
Thank you, Judge.
Appreciate your help over there.
Yes, sir.
We're gonna take our mental health break.
All right, let's say 3:00, since y'all haven't had a break yet, 3:00.
Okay, is Mr. Schmidt gonna remain there?
Yeah, he'll be over there shortly.
Your Honor, can you hear us now?
Yes, I can hear you.
Okay.
Mr. Sanders, is your video on? It's off on my side.
There's no X on it here on my screen, but I'm not sure.
Are you on a phone or a laptop or a
I'm
PC?
on a desktop, yeah. I'm
You
not
might
sure
not.
what.
You might not have a camera.
Well, and that may be the case. I thought
I
I've
know,
used
I
this
know,
before.
I think I know what the issue is, Jeff. I think if you'll just go to the application, you have to okay the application. You have to okay the camera to have access to the application. Do you know how to do that?
I don't think so. Let's see. No.
So basically, you have to tell your PC that it's okay for Zoom to access. So if you'll go into, if there's a Zoom setting, it'll ask you to
Like settings.
allow the camera or not allow the camera. If you don't think you're going to get anywhere on it, we'll just proceed.
Yeah, I'm not really sure. Let's see.
All right, we'll proceed and then you can work on it and then next
Okay.
time you can get it. All right, this is cause number CR 25-251, 252, 253, State versus Anthony Guevara Salazar. We're set for pretrial. Any announcements, Mr. Sanders?
Yes, Judge. We do have the discovery, and we are talking more with the state as far as a plea offer goes. I was going to ask if we could just go ahead and set it on a docket for the next hearing. And Judge, he has I think we'd mentioned this last time, he has a pending felony in Smith County, also out of the same transaction of events. And it's a first degree felony. So I think that, and I've been in discussions with the DA's office here in Smith County. So I think we're moving in the direction of getting that case worked out. And I think that'll kind of take care of the Van Zandt County cases
Okay.
where we can hopefully get a plea done soon.
When's his next setting in Smith County? Has he been indicted?
Well, he doesn't have any right now since he's here in Van Zandt. So really, I think if we could, if it would work to do the end of April, and I think I should have something ironed out with Smith County, and then we can go ahead and proceed with these cases here.
Is he indicted in Smith County?
He is.
But
And
he
one of
doesn't
the
have any
cases-
settings?
No, just because he's, I think they weren't going to do any settings until they had him in custody in Smith County.
Okay. And you said, what's his charge over there? First degree what?
It's an aggravated assault of a peace officer.
Okay. Because the highest charge we have is a third degree.
Right. Yes.
Okay.
So,
All right. Then you want me to set it for the 28th?
yes, if we could do that, that'd be great. And I think
All
we
right,
should
cool.
have something more definite by then.
All right. Court sets Mr. Guevara Salazar for docket call April 28th at 1:30.
And Judge, I went ahead and had him sign a reset notice, so I can just email that to Patty if you'd like me to.
Sounds good.
Okay.
Yeah, that'd be fine.
Okay. All right. Thanks a lot. I'll work on my camera for next time then. If we
All
need
right.
it.
We appreciate it, Mr. Sanders. Thank you.
All right. Thanks. Have a good day.
All right.
You didn't hear any of that.
Your Honor, we didn't hear the speaker went off, and so he didn't hear anything.
He didn't hear anything. Okay, let me summarize it. Mr. Sanders said that he wanted to set his case off for docket call because and he reminded the court that Mr. Guevara Salazar has a pending indicted first-degree felony case in Smith County on I think he said aggravated assault of a public servant, and he thinks that if we reset to April 28th, he might have something ironed out in Smith County that would then help take care of these cases in Van Zandt County. Court granted that request and set him for docket call on April 28th. And he indicated that Mr. Guevara Salazar does not have any settings in Smith County at this time because they were waiting to get him back into custody. So I think they were kind of deferring to Van Zandt so that Van Zandt could wrap up charges before they had him brought back to Smith. We have anyone else that's ready? Mr. Schmidt, who would you like first? No, I'm sorry, I didn't hear you. Mr. Hartwell, are you getting any audio from the jail? I'm not getting any audio.
No, Your Honor, I can hear you just fine, but I can't hear anything from the jail.
Your Honor, can you hear me?
Yes, I can now.
This thing keeps going off on its own, Judge. The new speaker that they bought for this.
Is it battery powered or is it hardwired?
It's hardwired.
And Sergeant Martinez, where are you standing in relationship to Mr. Schmidt?
Right here.
Okay, all right. Go ahead, Mr. Schmidt. And who do you have with you?
This is Mr. Barden.
Burden. All right,
Barden.
court calls, Barden, I'm sorry. CR 25-191, State versus Nicholas Bradley Barden for docket call. Go ahead, Mr. Schmidt. I believe it's final docket call.
It is. We'd ask to.
And I think the microphone is off. Is there any alternative microphone or speaker that we can use for today? Or is this it?
Judge, can they log on with their tablets that they have,
I don't know.
or maybe their cell phones to Zoom?
It all depends. There's rarely any connection in the jail, either cellular or Wi-Fi. That's the biggest problem we have back there is we can't get any kind of Wi-Fi in the back part of the jail. Therefore, the communication, the devices that we're having to use are usually personal devices to establish a connection to make sure that we have the ability to have jail court.
I had a set of speakers in here, but I don't have a microphone.
That's okay. They'll
It's
figure
on
it out.
right now. I'm trying to, what else can I do, Judge? Phone?
I can hear you at this moment, Fabio.
I know. When it goes off, I'll raise my hand over Mr. Smith because it just goes off on its own.
If it goes off, we're gonna know it.
Here, you'll see it because when it's not green, it's off.
All right. All right. I'm sorry about that, Mr. Schmidt. All right. Final docket call from Mr. Barton. Any announcements? And I think it just went off. All right. We're gonna have to, yeah, let's abandon that thing altogether. That's not gonna work. Might as well just unplug it and turn it off. We'll let Mr. Schmidt get logged in with his iPad.
there.
All right, we're gonna use your iPhone.
Yes, we can hear him.
I don't think that's gonna work either. It's so choppy that, yeah, that
Yeah.
iPhone's not, your signal's not strong enough.
All right. It's.
Mr. Schmidt, are you attempting to log in? 1 for yes, 2 for no. Oh, proper finger, okay, sort of. I guess if this doesn't work, we'll load up all the inmates and bring them over here to the courthouse.
Can you hear me, Judge?
All right, I fixed that. Yes, I can hear you.
All right, good.
Yeah, there's somebody else has got a microphone going on in there.
Okay, how about now? That's better.
Much better, much better. All right. Let's talk quickly, move quickly. All right, I'm gonna try it again. CR 25-191, Nicholas Barton, final docket call announcement.
Yeah, we're asking to set for a plea on April.
Did you say April 28th?
Yes, sir.
All right, court sets Mr. Barton for plea before the court, April 28th at 1:30.
Okay, you're good. Parents on.
All right, court calls cause numbers CR 25-192, 193, 194, 226, and 277. State versus Joseph Lee Barentine. I believe that we're set for pretrial in all cases. Go ahead.
That's correct, Judge. On all cases at this point in time, we don't have contested pretrial motions that need a hearing, so we're asking for a docket call.
April 28th. Okay.
Yes, sir.
All right. Court sets Mr. Barentine for pretrial in all cases, April 28th at 1:30. I'm sorry. Set for docket call. I said pretrial. Set for docket
Yes, sir.
call.
Jeremy Corley.
Jeremy Matthews Corley, CR 25-264-265-266. And Mr. Corley is set for docket call. Go ahead.
Judge, I think we're pretty close to a resolution. I have a offer from the state. I have not had an opportunity to meet with Mr. Corley about that offer, but we'd ask for a final docket call.
Any objections from the state?
No objection, Your Honor. Thank you.
All right, court will set Mr. Corley for final docket call, April 28th in all cases, 1:30. Who's next?
Clayton Furlow.
Clayton Dean Furlow, CR 25-182.
Judge, we have, I think we're set for a docket call on Mr. Furlow.
Correct.
And I met with the state last week. We have a tentative agreement. I have not had an opportunity to speak with Mr. Furlow about that. It's going to require funds from the court as well. I think that we could probably get it wrapped up within 30 to 45 days, but we'll ask for another docket call.
Any objections from the state?
No objection, Your Honor. Thank you.
You want April 28th or May 12th?
Let's do April 28th for now, Judge, and see if we can't get it done before then.
All right. Did you say final docket call?
Sure.
April 28th at 1:30.
That's what we're taking days to get. Thanks. Good.
Who's next?
Dylan Garrison.
Dylan Dale Garrison, CR 26-10, set for arraignment.
Yes, sir. Received a copy of the indictment on Mr. Garrison. He understands the nature of his charges. We would waive formal reading of that to set it for a pre-trial, April 28th.
All right, court enters Mr. Garrison's plea of not guilty until the record finds that he's waived the formal requirements of arraignment, sets pretrial April 28th at 1:30. If Mr. Garrison makes bail, his hearing will be same date at 9 a.m.
Yes, sir. Yes. Sure. Not exactly. Sure. That's what that is. I see. Get that. Okay. All right. We'll try to get this done. All right. Good. All right. Thank you so much. All right.
What do you want next?
Robert Glass.
Robert Wayne Glass, CR 25-201. Mr. Glass set for docket call.
Judge, we'd ask for a final docket call.
Any objections from the state?
No objection, Your Honor. Thank you.
Court sets Mr. Glass for final docket call April 28th at 1:30.
Yeah, Mr. Glass, I'm having issues with the jail. As soon as I get those worked out, I'll come and talk to you about it. Mark Martinez.
Mark Anthony Martinez, cause numbers CR 25-97, CR 25-122. Mr. Martinez is set on status. I believe we have him here on a bench warrant from TDC. Is that correct?
That is correct, Judge. And now that we have him back, I think we're pretty close to a resolution. I just need to talk to Mr. Hartwell one brief time. But we get a reset on him, a short reset. We don't want to.
28th is the next Thursday that I have available. So that's, other than that, could be Thursday of this week or the 23rd, but both of those are Thursdays.
Say April 23rd, or what was the earlier one? Thursday the what?
This Thursday, April 2nd.
Let's try this Thursday.
Okay. Court sets Mr. Martinez then for, I don't know what we're going to set him for. We'll just call it status again.
Oh, this is a dot cause.
April 2nd at 1:30, or April 2nd at 1:30.
Listen, I'll have something for you. Oh, Thursday. Let's see Thursday. Thank you. Thank you. Robert McInturf.
Robert Walter McInturf, CR 26-4, set for pretrial.
Judge, we don't have any contested pretrial. I have met with Mr. Hartwell here recently, and I think I've almost got him convinced to accept the defense offer. And ultimately, what we want to do is set him for the Thursday as well. I think that if I talk to Mr. Hartwell, we may be able to get Mr. McInturf out of here.
This Thursday?
Yes, sir, if I could.
All right, court will set Mr. McInturf for docket call April 2nd at 1:30.
Yeah. Eli Steele.
Eli Joshua Still, CR 25-219, docket call.
Judge, we're going to need some additional time on Mr. Steele's case. And I think Mr. Hartwell could speak on this, but I think when we discussed it, there may be some additional evidence. I could be speaking out of turn here, but that's what I recall. Either way, we're not ready to proceed, and I'd ask for an additional docket call on him.
No objection to an additional docket call, Your Honor.
Is there additional evidence being provided, or what's the reason for the extension?
Your Honor, it's not so much any additional evidence. It's a matter of proving up the evidence that we have at trial.
Okay.
Yeah, I understand what he's trying to say.
All right.
Just the way that the chain of custody is. Go ahead.
I was going to say court sets for final docket call April 28th.
Charles Wilson.
Charles Wilson III, CR 26-19 for arraignment. Also CR 2617, CR 2618, also for arraignment. Go ahead.
Judge, in each case, we've received and reviewed a copy of the indictment. Mr. Wilson's name is spelled correctly. We'll waive formal reading of those documents, and we'll enter in pleas of not guilty to all of them and ask for a pretrial setting.
What date do you want, Mr. Schmidt? Do you want the 28th or something a little longer?
The 28th should be sufficient, Judge.
All right, court sets Mr. Wilson for pretrial hearing in all cases April 28th at 1:30. The court does enter his plea of not guilty into the record, finding that he has waived the formal requirements of arraignment in each case.
Right now, yeah. Mr. Walsh.
Clay Press Walsh, CR 26-16, 2026-20. Show that we're set for arraignment on the CR 26 case and pretrial on the 2026 case. Go ahead, Mr. Schmidt.
That's correct, Judge. The arraignment on the CR 26 case, once again, his name is spelled correctly. We understand the charges. We'll waive reading and enter a plea of not guilty. We'd ask for that one to be put on a pretrial and carry the pretrial on the misdemeanor with it.
All right, court enters Mr. Walsh's plea of not guilty into the record and sets both cases for pretrial April 28th at 1:30.
The judge on Mr. Walsh, I had negotiated some bond reductions on his behalf with the state. I e-filed those, and I think I talked to Miss Tabraham, and I emailed her those proposed orders. It seems to me like in hindsight, the clerk rejected one of those because of, I don't know, a Scribner's error. But I'd asked the court to take up Mr. Walsh's bond reduction request. Yeah. I went to civil court. Yeah, I know. Okay, he did know that. Yes. Okay. And he said he would.
All right, the court. All right, let's see. And Mr. Hartwell, what have you agreed to on behalf of Mr. Walsh? It looks like there's an agreed order for bond reduction to a personal bond on the violation of a bond or protective order, and an agreement with regards to a reduction to $10,000 cash or surety on the assault, family violence, impeding breath or circulation. Is that correct?
Yes, sir.
All right, and so the current bond is $45,000 set by the magistrate on the assault, family violence, impeding, and $15,000 on the violation of bond or protective order. Mr. Hartwell, can you tell me anything regarding the nature of the case as one of the factors of bail that the court has to take into consideration, especially with regards to the personal bond recommendation on the violation of bond or protective order?
Yes, Your Honor, if I could have just a moment to pull the case up.
And Judge, while he's pulling that up, it's my recollection that before I filed a motion to transfer the misdemeanor to your court, he had the 30 days allowable for a filing of a complaint and information had elapsed. And at the time I filed a writ in the county court of law on the misdemeanor case 17-151 for delay. Simultaneous to me discussing that with the DA's office, I believe that one of the prosecutors sought a motion to forfeit bond on the felony case. Mr. Walsh was on bond on the felony case. So delay on the 17-151 on the misdemeanor, and we're asking for a reduction on the felony case that was timely indicted.
You said that the DA's office moved to forfeit the bond on the felony case?
They did, Judge. Basically, what happened was when I filed the writ, and before I filed the writ, I communicated with a misdemeanor prosecutor, and he decided that he was going to file a motion to find bond insufficient on the felony with the JP court, and the JP judge granted that motion ex parte, and so after that, I found out, and then we transferred the misdemeanor to run with the felony. so that we can get all this in one fell swoop.
So the bond's been moved to forfeit, or not, there wasn't a move to forfeit the bond. There was a release of surety.
No, sir. There was a motion to find bond insufficient based on the misdemeanor arrest filed with the Justice Court by the
Okay.
DA's office, and then the JP judge granted that ex parte.
Okay.
And Your Honor, one of the factors that I considered in agreeing was I can't speak to the nature of the failure of service to Mr. Schmidt, but the fact that Mr. Schmidt wasn't served with that motion was one of the factors I considered. As far as for the court's consideration, I can tell the court there is a prior arrest for an assault family violence. However, it does not appear that resulted in a conviction.
Is the alleged victim in the choking case the same as the violation of bond or protective order?
I believe so, Judge, and I also believe that she is the petitioner in a family law case that's before your court recently filed.
Okay. And Mr. Hartwell, do you agree with Mr. Schmidt that the DA's office did not timely file the misdemeanor case and that he's entitled to personal bond under 17-151?
Yes, Your Honor.
Okay. All right, then the court hereby grants the agreed order for bond reduction to a $5,000 personal bond for a violation of the bond or protective order. Court finds that the defendant is entitled to this order based on the DA's office failure to timely charge Mr. Walsh with the misdemeanor offense, and therefore he is entitled to it under Article 17-151 of the Texas Code of Criminal Procedure. Court is signing an order granting that personal bond. With regards to the agreed order for bond reduction for the assault, family violence, impeding breath or circulation, the court hereby denies the defendant's motion. Court will maintain bail on that third-degree felony at $45,000. So, Mr. Walsh, we'll see you back on the 28th. If you make bond, then your hearing will be at 9 a.m.
Judge, may I have just a moment before you recess on Mr. Walters' case?
Yes. Hey, Mr. Schmidt, if you want to unmute, I muted you while you were talking to Mr. Walsh because I didn't want Any attorney?
Yes, sir. Thank you.
You're welcome. You're welcome. All right, who do you have with you now?
This is Area Gilchrist.
All right, court calls numbers CR 25-200 and 2023-77 State versus Ariella Fallon Gilchrist, set for motion to adjudicate, pretrial, and motion to reduce bail. Go ahead, Mr. Schmidt.
Judge, on the pretrial matters as of today, I don't need a hearing on the pretrial. We're asked to set that for a docket call and carry the misdemeanor NTA with it. And then we're asking for that April 28th date.
Okay. All right, court will set Ms. Gilchrist then for docket call and CR 25-200 to April 28th at 1:30. Court will carry the motion to adjudicate with even date. All right, and on your motion to reduce bail?
That's correct, Judge. We have a motion to reduce bail in both cases. Just historically, Judge, because of my current issues with bringing things into the facility here, I managed to come in without my briefcase, which has my motion. But I believe, and Mr. Hartwell can correct me if I'm wrong, I can't flip back and forth on my tablet since we're using that for Zoom to look at my file. But believe we had an agreement on the motions to reduce bond, and I cannot recall what that was. And I may be thinking of somebody else.
Your Honor, as far as the agreement, yes, there was an agreement, and part of that is Miss Gilchrist is the alleged victim in a case that's currently pending trial, and so as far as trial preparation and all that, having Miss Gilchrist available to come and meet with us was one of the factors that we were considering. I think the bond on the MTA may actually still be in place. I'm not 100% sure. But state was in agreement with reducing the bond on the drug charge so that she would be able to make bond and be able to be available to meet with the DA's office for that trial.
What's the state's recommendation? There was nothing written on the agreed order.
As far as that, Your Honor, I'd defer to Mr. Schmidt.
Well, he says he can't remember, and he doesn't have his briefcase, and he can't toggle on his iPad.
And I could throw a number out there. I think that would speak for myself. But we'd ask for a $10,000 cash for surety on that felony case.
That's your agreement, Mr. Hartwell?
I didn't say it was his agreement. I'm saying that's what we're asking for.
Well, I know that's what you're asking for, but he says he's in agreement to the reduction. I want to know if he's in agreement to that reduction.
Yes, sir.
Your Honor, state would be fine with a $10,000 bond. I think that keeps Miss Gilchrist with a bondsman to check in with and would serve everybody's purpose.
All right, we'll take that under. Go ahead.
One final thing. One of the things that's gotten us here is Miss Gilchrist had issues with transportation, and she missed a court date. So that the court found her bond sufficient for missing that court date based on her transportation issues. I've been in contact with her family, including her mother, and she's assured me that those issues have been resolved or will be resolved and won't be a problem going forward. But I think ultimately, she has appeared for all the cases that I've had her on, except for the one where she had transportation issues.
Okay. All right, court will take that under advisement. I will check the PSRS system as I'm required to do, and I'll go back through to verify those.
Thank you, sir.
You're welcome. And I'll issue a decision at the conclusion of the docket.
Right. So you won't know until sometime later this afternoon whether he grants that bond or not. Sit up there. All right. And I'm gonna need a few minutes and I have
You're kind of breaking up. I can't really hear you. I heard that you're going to need a few minutes, so I'll just stand in
Yeah, sure.
recess. I'll stand in recess until you come back online.
Sure, thank you.
You're welcome.
Yeah, I'm a little bit frazzled.
Kind of a funny face freeze there.
I think it's talking to me. Oh. This makes me look a lot better than I am.
All right, Mr. Schmidt, who are you ready on?
This is Seth Atkins.
All right, court calls cause number CR 22-368, CR 25-279, State of Texas versus Seth Edward Atkins. Are we doing a plea today?
Yes, sir. You should have the paperwork in your queue.
All right, give me just a moment. I'm going to pull it up.
Yes, sir. What? Right here. Be able to put this out. Oh, good. I've never been able to do more than one thing on electronic device without killing it. $638. Remember that number, $638. Yeah.
Yeah, the connection is not real well, but we're gonna real good, but we're gonna try to figure that out. All right, Mr. Atkins, if you'll
Yes,
raise
sir.
your right hand, I'm gonna place you under oath.
Sir.
Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you. You can lower your hand. If at any time you can't hear me, please let me know.
Sure.
All right, Mr. Atkins, in cause number CR 22368, there appears to be a plea agreement, and it appears to be based on the state's motion to adjudicate your guilt. You were in this court on June 1st, 2023. You pled guilty to the third-degree felony offense of assault of a household or family member by impeding breath or their circulation. The court heard the evidence and then followed a plea agreement that you reached with the state. On that date, the court placed you on deferred community supervision for a period of 10 years and assessed a $2,500 fine. It was during your period of community supervision that the state has filed its motion to adjudicate and revoke. And in that motion, they have alleged 8 separate counts of various allegations of violations. Have you had enough time to review that motion with your attorney, Mr. Richard Schmidt?
Yes, sir.
And are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
Do you have any questions about any of the documents that you have read and signed?
No, sir.
And it appears that the agreement you want the court to approve today is that you would be pleading true to counts 1, 2, 3, 4, and 5. And in exchange for that plea of true, the state's recommending that the court adjudicate your guilt, means convict you of the offense, for your community supervision to be revoked, and for your punishment to be assessed at 4 years confinement in prison, and also ordering you to pay the balance of the monies that you owe, which is your fines, your restitution, and your court costs. And you would receive credit for any time that you've spent in jail on this cause. Is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Schmidt, does your client waive the formal reading of the state's motion?
We do, Judge.
And I also see, Mr. Atkins, that in cause number CR 25279, the state has filed a motion to dismiss that matter. I don't think that's part of your plea agreement, but it is something that they have tendered to the court. So with that understanding, the court is going to ask you, Mr. Atkins, how do you plead to counts 1, 2, 3, 4, and 5. Are those counts true or not true?
Yeah, sure.
And Mr. Atkins, has anyone threatened you, forced you, or pressured you to plead true to any of those counts?
Sure.
I'm sorry, say again.
No, sir.
Okay. All right, the court will accept the defendant's plea of true to those individual counts. Mr. Schmidt, any objection to the evidence that's offered being admitted?
Okay.
All right, the evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then based on the evidence before the court finds that Seth Edward Atkins has violated the terms and conditions of his community supervision. The court finds counts 1, 2, 3, 4, and 5 to be true. On that finding, the court hereby follows the plea agreement, adjudicates the guilt of the defendant, revokes his community supervision, assesses punishment at 4 years confinement in the Texas Department of Criminal Justice, and orders him to pay the remaining balance owed on his fines, restitution, court costs, and reimbursement fees. Mr. Schmidt, what is the credit time that Mr. Atkins is entitled to?
638 days, Judge.
The court hereby awards Mr. Atkins 638 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Atkins, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. Once you're released from prison, Mr. Atkins, if you've not paid off your fines, fees, and court costs, then you are to report to the district clerk's office and ask about a payment plan. Failure to do so could result in the court issuing a warrant for your arrest. Do you understand?
Yes, sir.
All right. Thank you. Good luck to you, sir.
Thank you.
You're welcome.
Oh. Good. Did you already thumbprint? Hey, did he thumbprint you already? Okay, you're good. Good to see you. Yeah. I think that's all I had. Is that all you have?
Give me just one moment. Let me check. I'm going to sign these, please, and then I'll look through it.
Switch over to the jail
When he's through.
when you're done with me.
I do see one more for Mr. Zachary Campbell, although I can give the court an update on that one. It's a prosecution status.
All right, court call CR 25-32, State versus Zachary Dale Campbell. Yes, we had a prosecution status. Go ahead, Mr. Hartwell.
Yes, Your Honor, and I apologize. I thought I had filed a motion to dismiss on this case. He received a TDC sentence out of Kaufman. So because of that, state will dismiss this charge.
All right, go ahead and file your motion e-file, and I will get that signed and dismissed for the state. And
Thank you,
Mr.
sir.
Campbell, you're welcome. Thank you for following up on that, Mr. Hartwell. I do appreciate it.
Yes, sir.
All right, I believe, unless Ms. Tabraham thinks I'm mistaken, that does appear to be. Actually, we do have not concerning you, Mr. Schmidt, but I do need your iPad for just a second. Court call CR 25-180, State versus Laterios Untre Bates. We're set for arraignment. He is still verified in the Bird unit in TDC. Any announcement on that, Mr. Hartwell?
Yes, Your Honor. This is the one we were waiting on the status of that appeal. I saw in the appellant's brief was due on March 12th with no further extensions being permitted. It still has not been filed with the Court of Appeals. So there's now an order giving the appellant until April 3rd to file a brief along with a motion for leave to file a late brief. And if not, then it's going to be set for hearing. I presume, Your Honor, just from the length of time and the lack of response from the appellant, that it's going to end up being an Anders brief. But I'd just like to be able to confirm that if we could get maybe a 60-day status setting on it.
Yeah, I was on the same page with you. Court will set Mr. Bates for status on May 12th. And we'll revisit that and see if that's moved anywhere.
Thank you, sir.
All right, that does complete the court's criminal docket and court is adjourned. Thank you
Your
for letting us
Honor,
use-
did y'all do Miss Moffett?
Oh,
Kiara Moffett, the one that did?
no, I have not. That's from this morning, correct? Yeah, we'll bring her in. So
Yes, and
don't
I
panic.
believe she's out.
I need to get her paperwork to see if she is indigent. So. All right, you can go ahead and log off, Patty. And so that you can give Richard his device back. Thank you for letting us use that, Mr. Schmidt. It was a lifesaver.
Yeah, absolutely. Thank you, sir.
Ms. Moffett, just come on up here to the podium. Oh, all right. We're on record in cause number CR 20-298, State of Texas versus Kiara Monique Moffett. Ms. Moffett, you were said at 9 a.m. this morning, and I understand that you had trouble transportation issues. Is that correct?
Yeah. Yesterday I was texted about my brother, so I have proof of it.
Oh, goodness. I'm sorry. Okay. We had you set today on status to hire an attorney. I think the last time you were in court, you indicated that you wanted to hire an attorney. Were you not able to do that?
I've been taking for 90 days, so I don't know when that, how long that actually takes, so I just did the paperwork for the appointment with, lady from. Cause I didn't know exactly if it's gonna take the minimum 60 or the full month.
Do you know what you're expecting to get back on your tax return?
Yes, sir.
How much is that?
I mean,
9,000? Okay. That's going to move you out of indigency.
you said that's.
That's going to move you out of indigency. It's going to mean that you're going to have the ability to hire your own attorney.
And so, yeah, I spoke with, he was, saying 7,000, he was saying 3,500, to start, and then figure it out, I was just gonna do a lot of work, so we have to bring it, just be that way. But like I said, I don't know how long the review is going to actually take, so that's why I'm getting the paperwork for the quarter, just to be on the safe side. That was my for doing for the quarter.
Mr. Hartwell, are you there?
Yes, Your Honor.
All right. Did you hear the statement by Miss Moffett?
Not much of it, Your Honor.
Okay. Well, the court has just inquired about her indigency status, and she's filed an affidavit of indigency, but she's indicating that she's supposed to get a $9,000 tax return. And the court has indicated that the court has to take that in consideration in determining indigency. If I reset her for an additional 30 days, is there any objection from the state? She's been indicted for false statement for property or credit between $2,500 and $30,000. And I believe it's an older case. It said it was filed in October of 20. So, are there any objections if the court resets her for one more status to hire attorney?
No objection, Your Honor.
All right, so Ms. Moffitt, the best I can do for you is I can reset you maybe a little bit longer. I'll reset you to May 12th. And hopefully your tax return comes in by that time. So we'll do that. And so having that kind of tax return as an asset is going to be something the court has to take into consideration. So the court appointed an attorney and have the taxpayers pay it for you when you have some discretionary income, plus you're expecting to get such a large amount of money back to use towards your legal defense. So what I'll do is I'm going to get a notice of setting and have you come back on May 12th. Okay. Do you have any money saved up for an attorney? Do you have any saved up though? How much do you have saved up?
That's why I was depending on my tax return to take care of that, because I didn't have two children, so.
All right, come on up. I'm gonna have you sign right here where it says defendant. This is just a notice of appearance saying that I'm gonna have you come back on May 12th, 2026 at 9 a.m. on the issue of status to hire an attorney and also for arraignment.
Okay.
Here you go. And I'm going to give you this copy right here. All right, so I want you to extinguish all of your options on hiring an attorney
Right.
by May 12th.
Okay,
Okay,
I will.
I can't give you any more resets after May 12th.
I understand.
Okay,
Okay, thank you.
all right, free to go.
Let them know that we've been discussing it.
Your Honor, hold on one minute. Miss Moffett hasn't left yet.
Miss Moffett, hang on
just one second.
Yes.
And Your Honor,
In the meantime,
I apologize that we've gotten to the end of the hearing here. We've been looking at this case and I was just reviewing our notes. given the age of the case, Your Honor, and just some of the, moving furniture around, state does not believe we can locate all of the witnesses that would be needed. So, Your Honor, state's going to go ahead and move to dismiss at this point.
Okay. All right. So Ms. Moffitt, the state has just made an oral motion to dismiss the case. I'm serious. And so I'm going to grant that today, and you can just throw that piece of paper away. I'm going to sign the order. If you want to get a copy of it, you can always contact the district clerk's office. It won't be signed. It might be signed later today, but maybe not today. It could be tomorrow. But you can always call them and have them provide you a copy. All right. Well, you can thank Mr. Hartwell, Mr. Hernandez. So you're free to go. You're welcome.
Thank you, Your Honor.
You're welcome. Thank you for that announcement, Mr. Hartwell. All right, I think now that does actually conclude the court's criminal docket, and we are adjourned. Thank you, gentlemen. Appreciate your work.
Thank you, sir.
You're welcome. You have a great day.
You too.